Hi, everybody. Hey, it's Craig Freshley here. And as you can see, I have a special guest. This is Henry Chance. Henry has been a fan of my good group tips for many years. And recently, he sent me a PowerPoint presentation that he gave at his company. And lo and behold, this presentation was riddled with references to my good group tips. He was using them in a real life application. So I've asked him to come into the office today and tell us a little bit about what that presentation covered. Henry, welcome.
Thank you. So, as I was saying, the reason that I got inspired to do this brown bag lunch for my company is our company's name is DRT Strategies, and DRT stands for Driving Resolution Together. And so I figured that if we're going to be a company that has that in our name and in our brand, we should be a company that is really good at running meetings.
Right. So and I know that you have a culture at your company of giving these brown bag lunches to each other so you can do shared learning. And you gave a presentation on this particular experience. Can you tell us about that?
So in November of 2016, I was asked by the District of Columbia to preside over a jury. And that's not something that you're actually volunteered for. You're voluntold to go to jury duty like everyone else. And so while I was there hearing about this case, due to the seating arrangement in the jurors' room for deliberation, I ended up being closest to the whiteboard and the markers, and so it became very convenient for my fellow jurors to pick me as foreman.
This is classic, right? The guy who just happens to be sitting closest to the markers gets chosen as the facilitator. In this case, the jury foreman. So this was a pretty high stakes trial, right? There were 3 charges, had to do with drug possession. We don't need to know all the details of the case, but how did you find yourself applying the tips and your other meeting facilitation skills in a jury deliberation kind of setting?
So the most important thing for me to get through the trial as foreman was I needed to find a way to reframe what I was doing. I don't have any legal background or expertise, which of course is one of the reasons why they pick people with non-legal expertise to be jurors. But I still needed to get through this, and I still needed to help everyone else get to a verdict. So I framed this as something I did understand a lot about, which was running meetings.
Right. I can hold this, by the way. I know it's a little awkward. We've got one mic between us here. We'll just take turns. So you do run meetings in your job as part of your job. And so you treated this as another meeting. This is like a way that I can add value. This is a skill that I have. And I know you and I chatted before we started the camera running. You took this meeting facilitation job very seriously, right? You wanted to be neutral to serve the group. Tell us about that, because oftentimes people are in a position of needing to be neutral and serve the group as facilitator, yet at the same time having a strong opinion. And you were beginning to develop an opinion about this guy's guilt or innocence. How did you manage that?
So before we started the actual deliberation, the judge read instructions to the jury about what we were supposed to do, what we were not supposed to do. But one of the requirements that we had before we started deliberating was finding out that our verdict had to be unanimous. So we, whatever decision we came to, we had to all agree that on the 4 counts that he was charged with, he was innocent or he was guilty unanimously for every single verdict. So, my job became not persuading everyone to come to my opinion, what I believe. What was going to get us through the meeting was to get us to a point where we could all, agree with confidence that, our opinion was right.
Right.
And if I could get everyone to agree together that this was the right choice, then, given that there are 12 people in the room, we were probably going to have confidence that we had reached the right call.
I love that. Many times when I'm the facilitator, I'm perfectly comfortable setting aside my own opinion because I trust in the group. And especially if it's a situation where unanimity is required, I would be able to say, look, if all these other 11 people think the same way and it's been a good process that I have managed, I'm probably going to vote right with them, and that lets me let go and not lead with my opinion. It sounds like you did that a little bit too. What were some facilitation techniques that you learned from my tips or that you've learned in your works that you found particularly helpful in managing this jury deliberation?
Well, I think that this was a very high-stakes trial in the sense that everyone's emotions were very piqued by the facts of the case and the facts of the world around us. This trial took place the week of the 2016 presidential election, and we heard the trial on Monday and Tuesday, and then on Wednesday, the day after the election results, is when we began deliberation. So what I really tried to focus on, in my role as foreman, was getting people to set their emotions aside, and it wasn't a scenario where I could say, okay, guys, take your emotions and set them aside. I had to actively and subtly find ways to get them thinking about the facts of the charge that we were talking about. And since the four charges had some interdependency, but in some ways they are independent of one another, I had to say, look, we know that there's issues with these other three charges, but let's just focus on this one charge right now. What do we know about this? What do we not know? What are our concerns? What questions do we have?
Right. I want to ask you in a minute how some techniques, if you can remember, that you used to focus the group. Because in this case in particular, you had a lot of boundaries. You were required by law to focus on certain things and actually let go of other things. Like the judge told you that sentencing is none of your business. You were instructed that there were other things that were clearly out of bounds. You didn't have a full array of options to you in every case. You had to get this group focused on, one charge at a time and one charge within certain parameters. Can you remember some specifics that you did to help focus the group?
One of the things that we did to help focus the group, and what you alluded to with the judge saying that the sentencing could not play into our decision, was we had to separate the truth from the consequences, and that was very difficult to do because we knew that some of the charges were small and we're going to have small consequences, but other charges were going to be life-changing for both the defendant and for everyone who knew him. And so all we could do was just try and say what happened, and the way that we got people to we got each other, really, because this was a group participation, really, to get to this verdict, to the verdicts, I should say, is that we would work on part of a charge, the parts we knew, and when the emotions got high, we would step back and we would take a break. And when we got to an avenue where we didn't have enough information, or we needed to send a question back to the judge, we would work a second angle and then come back and take a break.
I love that. That's a technique that I often use. You work on one part of the problem for a little bit, and then you take a break and work on another part of the problem, and then come back to it. I find that that's really useful. Another technique I know that you used in this jury deliberation was straw polls. And there was some resistance to when you suggested a straw poll, and almost always when I suggest a straw poll, there's resistance. Can you tell me how that worked, and how they came around to doing straw polls later in the deliberation?
So the first straw poll I took was actually fairly foolhardy. On the first charge, I asked, and it was the way they outlined the charges, the most severe charges were the first in the order. So we took the most severe, most consequential charge, and immediately I said something to the effect of, "All right, who thinks he's guilty?" And I was more tactful than that at the time, but what I said versus what I heard, they basically heard me and thought that was very cavalier, and so that was the wrong that was the wrong approach to take for that particular straw poll. But it got everyone talking about how are we going to figure this out? How are we going to analyze the facts of the case? And so we started getting a lot of intercommunication between the various people and what they thought was important, what they thought was not important. Later on, at the end of that day of deliberation, I attempted another straw poll, and this one was different in nature. We had resolved two of the charges. We determined verdicts for the smaller two charges, and the two much bigger charges that we had to contend with, I asked, without revealing what your opinion is, guilty or innocent, how confident do you feel in your opinion? Do you feel confident in your opinion?
How confident?
Or do you have doubts? And some people said, raised their hand that they felt very confident in their opinion, and then other people raised their hand and said they have doubts, they have questions, they don't have a clear opinion yet. And so that I was able to use that information.
Right. What did you do with that? Yeah.
I was able to use that information and say, all right, so for tomorrow's discussion, our focus is going to be on resolving doubts.
I love it.
And once we've resolved our doubts, then we're going to see if we all have strong opinions, that are all unanimous. And if we do, then our work is done. If we have strong opinions that are not unanimous, then we'll figure out what to do next.
Right. So how did you work on the doubt issue? I suppose if I was in a meeting facilitating, I would want to ask the doubters, what questions do you need answered to help you with your doubt? But what did you do? Do you remember?
Some people had trouble, I think, expressing, verbalizing what their doubts were, or why they didn't like the path we were going down. So we tried teasing out some of that with specific questioning about the nature of the charges, or the circumstances of the arrest. Ultimately, one of the things we did that was most effective was we wrote on a whiteboard. We graphed what the material was that the defendant was caught with versus previous cases that detectives referenced, and comparing that to other arrests they'd made to determine whether to try and determine what the defendant's intent was. And that was the sticking point in this case is we knew what the defendant had, but what did the defendant actually intend to do? And that was the hardest part of the trial.
I've learned about the trial, and in this case, a defendant was caught with illegal drugs, and a key question was, did he have intention to distribute? And that was the charge, one of the charges, probably the hardest one, and probably the one with the greatest consequences that you all had to deliberate on. You had, as is the case with all juries, and that's the wonderful thing about juries, you had a wide variety of people with different levels of experience with meetings and group decision making and all different kinds of opinions about how the process should be done. And you're thrown together not knowing each other. How did that work? How did you like get to know each other and suss each other out and even come up with a shared understanding of making this decision?
You know, it's funny. I don't think I could tell you 3 facts about any of my fellow jurors. We all, except for sharing names, we were all fairly anonymous, and so getting to know each other didn't really happen, and that was unusual, because normally I have ways I can interact with people or connect with them, and this was much more difficult. I don't think that there was any good way, given our circumstances,
right,
and given the somberness not only of the week for Washington D.C. being a very blue district, and for for the severity of the charges, there were several undertones, that undercurrents that ran throughout the trial. Questions of race, questions of police intent, questions of social class, economic class, that were never explicitly said, but were felt, at least by me, and I would not be surprised if other jurors felt those same tensions as we tried to sort out what happened.
Right. Well, this is fascinating, because there's a folklore out there among facilitators and group trainers and whatnot, that it's worthwhile investing time in team building, a warm-up exercise, that we're going to have a better meeting and our time is going to be more efficient, and we have a bigger chance of getting a good decision if we invest time in getting to know each other. But in this case, you invested like no time in getting to know each other. The stakes were extremely high. You sat down to business, and by the way, I hope I'm not giving it away, but this jury came to unanimous decision on all 4 counts. After how many hours of deliberation, Henry?
We had about 12 hours of deliberation spanning 2 days.
Right. So call it a 12-hour meeting, 4 unanimous decisions, and they invested no time whatsoever in a warm-up exercise or team building or anything like that. You set right to business.
And this was a difficult case. I would have been much more comfortable deliberating this with 11 other people that I knew, that I trusted, that I had previous experience with, because that would have allowed me to talk about things in ways that I was comfortable talking about things. My first straw poll probably would have gone over much better
among your friends,
amongst friends, than amongst a group of strangers.
Right.
But there was no good way for us to leave the formality and the somberness of the of the case to actually get to know each other better.
Right. So here's some other folklore out there in the meeting facilitation world, that humor is useful. I particularly love it when somebody cracks a joke, or if we can get the group laughing a little bit. I find that very helpful. Was there any humor in that jury deliberation room?
We had 2 small instances of humor, I think, two small opportunities during the breaks. One about the clock, which hadn't changed over to daylight savings time, and another about trying to find parking and the
Right.
and the metro to get to the place.
Yeah, yeah.
But otherwise, it was it was a very, very serious
Yeah.
serious meeting.
Yeah, right. Serious meeting.
Mhm.
I'm going to ask you about one more technique here, and then I want to ask you a general question. Any conclusions? If I suppose I'll ask it. If you had to do this again, be thrown into a facilitation role where you're required to make a unanimous decision, would you do anything differently? That question is coming. But first, another specific technique you used is one that I'm very fond of. I call it closing comments. You were near the end of the first day, and you had a little time left on your hands. Tell me a little bit about how you used that time.
So we reached a point in our discussion about the two most serious charges that where emotions had really taken over. The discussion instead of reasoning. So we weren't going to make any progress. We were going to go into the next day of deliberation. So with the time that we had left before we could be excused for the day, I tried to wrap things up. This is when I took the second straw poll to ask how everyone felt about their opinion, what they had doubts on, and I also took that time to outline the things that we knew were facts, evidence against, evidence on behalf of the defendant, things that we didn't know how to categorize, and then a last topic of what questions we had that we still needed to figure out.
A nice recap of
Right.
where you stood.
And we wrote all that down on the board and basically saved where we were in the meeting for next time.
Right. But you did give everybody a chance to say a last word.
I
right?
did do that as well, and that did a lot to ease the tension. There were a lot of people who were in one camp about the defendants who did not want to convict the defendant, and they were feeling rightly or wrongly more and more put upon by the majority who felt the defendant was guilty. And they took that opportunity at the end of the day to say, we're really feeling pressured, and we don't like that. And they had a captive audience. Everyone was listening to them,
Right.
and they had a chance to get that out there. Release that tension that had been bottling up inside them. And the next day, I think that they not only did they feel better that they were being heard, but they also didn't feel like they were pushing against a resistive force.
Right. That's so helpful to hear. So, any lessons learned here? If you had to do it again, would you do things differently? Yeah, tell me.
If I had to do one thing differently, I would have probably started out by saying, these are the four charges. Which ones do we want to tackle first?
Right.
We took them in sequential order, and that was the biggest mistake we made. We would have saved ourselves much more time and saved a lot of stress as well. If we had taken the very easy charges, the charges that not even the defense were denying or making a case against, because that would have let us set up our formal processes for taking the vote, for going through all the motions and procedures that we had to go through as a jury on a softball question compared to the really heavy hitters.
Yeah, Right. That's great to hear, and that too is very instructive and a good reminder. So many times, a group has a list of 4 things to do, and the impulse is, well, let's just take them in order. And honestly, I very rarely do that when I have the time to think about it, and when I'm not just thrown into a facilitation situation. But if you have time to think about it, to really think about what is the most logical, helpful, most promising order to take the issues in. When I asked you, is there one thing you would do differently? I thought maybe you were going to say not sit next to the markers. But
I had little control over that, unfortunately.
Are you glad that you served as foreman? I bet you are.
It is an experience that I would recommend to everyone. Is to, if you're called up for civic duty, to absolutely do it, not to try to get out of it, because if there's one thing that stuck in my mind after this whole thing is there's possibly no better place than to know where the health of our country's government than sitting in a courtroom as a juror.
Nice. That's a great closing comment. It sounds like you feel that justice was served in this case, and you were proud to be a part of it.
I take my civic duty seriously.
Nice. Well, thank you very much, Henry. It's been great talking with you. I really appreciate not only that you did your civic duty, but you were very serious and deliberate about applying good facilitation techniques, and you put it all into a PowerPoint presentation for your colleagues, and you came down here and talked to me about it. I really appreciate it. It's great.
Great to see you, Craig.